In State versus Bailey. Mr. Sloven.
Thank you, Your Honor. And may it please the court. Good afternoon. It's a privilege to be here. The trial court erred in dismissing the trial information. The trial court's role in a motion to dismiss is to determine if the trial information and the minutes allege the crime. The role is not to determine if an affirmative defense could be proven at trial. A finder of fact at trial will determine whether Mr. Bailey reasonably believed he had a right to make these particular threats. In Wilson, this court talked about or considered whether the legislature, when it said that a person has immunity from, under certain circumstances, immunity from liability, even that language didn't create a right to a pretrial determination on the applicability of the justification defense. Here, we don't even have that. The idea that there would be a weighing of the evidence in favor and against the applicability of this defense in 711-4 sub 3 at the motion to dismiss stage violates Gonzalez and also Doss and our other cases about the role of the trial court in the motion to dismiss phase.
I tend to think you have a valid point, but you're actually asking for more than that. You're asking, for the defense to be rejected as a matter of law. Don't we need to just, if we disagree with what happened here, reinstate the charges and let things go forward?
Yeah, I would agree with that. Now, and we say that at the end of the reply brief, is that whatever you say about the applicability of the defense on the facts in the minutes is kind of moot, because the trial court will have to make a decision about whether substantial evidence supports the submission of the defense based on the evidence at trial, not the evidence in the minutes. I do think that there's a role for this court in providing some guidance, because we don't really have a case that talks about what this defense means, what facts may be important in determining whether there is substantial evidence to support the submission of this defense, or when it may be correct. You could see the trial court needing that guidance when this case proceeds forward to trial.
Versus Ross, I think we discussed the instruction that would be applicable to this defense. Is that right? Right. So beyond that, what more needs to be provided, or what is unclear in your mind where district courts need guidance on how the defense applies?
Well, I think that the district court's rulings, its orders in this case, kind of illustrate that it's operating from a view of extortion that's basically, I know it when I see it. And we do want the jury to be able to apply that sort of intuitive understanding of what is objectively reasonable and bring the judgment of the community to bear. But in our roles, putting principles of law into words so that they can be made as arguments and written as decisions, we may need more than that. And it is helpful. That's why we did a lot of research, and we are offering up this nexus framework for.
Generally in our court, we don't like to do extra work. You probably figured that out. And what's wrong with the language of the statute? The person reasonably believed that the person had a right to make such threats to recover a debt to which a person has a good faith claim. And the jury can decide if, there was a good faith claim for $10,000 here. That's what's wrong with that.
Belief in a right to make these threats to it. I agree that. Well, I think that you're right that the language of the statute should form the bulk, if not the entirety, of a jury instruction, just as it did in Ross. Now, in Ross, this court approved or affirmed a district court ruling that rejected a defendant's proposed additional jury instruction that would have defined the crime of theft by deception, I believe, or maybe it was theft by check. Whatever crime that the defendant was saying that they believed that the victim had committed. And this court not only said, no, we don't instruct on those collateral theories, but also there's no substantial basis to believe that the defendant actually, or that the victim actually committed that crime. And we have serious doubts that the criminal or that the conduct of the extortion victim in committing a crime could ever be itself a defense to extortion. I think that's right on the money. That's in line with DeBolt and Browning, the commentary in Donahue on the new criminal code, that the fact that, and this was the basis of the motion to dismiss, is the argument that this forecloses. The fact that the recipient of the threat has actually committed the crime is not a defense to extortion. When the extortionate threat is, I will reveal this crime to the public or I will report it to prosecutors if you don't pay me a certain amount of money or give me something else of value. I think that it is important to say that clearly, and I think it's also important to give some guidance that helps courts navigate, because in considering how to approach this case, Section 711(4) sub 3 specifically excludes one kind of extortion from that defense, and it's the threat to commit a public offense. It doesn't exclude threatening to accuse somebody of a public offense. The legislature envisions that this defense can be raised in some instances where the threat to accuse somebody of a public defense is made to obtain something of value. Now, when is it objectively reasonable to do that? If it's not objectively reasonable, the defense fails. I think that we can refer back to common law and commentary on the code, and that can get us a certain distance. And the jury is going to apply their own common sense and lived experience in determining what they believe is objectively reasonable, as they do in cases involving justification and other defenses that involve this kind of language. But it can also be helpful to think of, to crystallize the principle here and explain why extortion is a crime and which threats are unreasonable. And the way that I think it's best to do that, the best explanation is, focuses on the nexus between the claim, the threat, and the demand. When paying on the claim, when complying with the demand extinguishes the claim, that helps show the relationship, the nexus between claim, threat, and demand. So return the property that you stole, or I call the police. If they return the property that they stole, I no longer have a claim for restitution for the item that was stolen. Return the property that you stole, or I publicize a marital infidelity. That required link isn't there. Not only that, not only does the following through on the demand doesn't extinguish the claim, and it doesn't prevent me from making that demand and that threat again. I can make the same threat to damage the person's reputation if they don't pay me even more money. And that's another factor. All of this is, I think, most succinctly set out in that second paragraph that we quoted from Jackson, where the court kind of summarizes some factors that would lead or that tend to negate the existence of a reasonable nexus between threat, claim of right, and demand.
He is an authorized agent to even be able to make that kind of a threat. He's not a law enforcement. I just found that to be an interesting discussion, whether or not he is, Bailey, if he lacked authority to even settle an alleged crime, when we're talking about a crime that's going to be determined by law enforcement.
Right, and that's one of the things, I think, Your Honor, that distinguishes this from a settlement demand regarding a civil claim, that everyone is the master of their own civil claims, but as Lindgren says, this kind of threat is bargaining with the state's chip. In fact, it's working against the state's interest. What Mr. Bailey says in the email is that your conduct poses a danger to the public. Well, and then he says, pay me $10,000 and I will conceal it from the public's representative who could vindicate that public safety interest. That's, helps to illustrate that the demand has no reasonable nexus to the claim of right. The concern that he's articulating about danger is actually undermined by payment of the demanded money and his lack of follow through on the threat in exchange. So and then after that, there's nothing to prevent him from coming back and saying, okay, another $10,000 or I will refer to you, do exactly what I threatened to do in the first place. And I think that generally, the statement from Ross speaks in pretty broad terms about doubts that a person can ever use the criminal's or the victim's criminal conduct as a defense to extortion. A reasonable belief in a right to make the threats is a different story. So it doesn't actually matter whether Coombs committed a crime. What matters is whether Mr. Bailey reasonably believed that he had a right to expose something, whether he believed he had a right to make these threats. The state isn't saying that every settlement demand needs to be supported by a factually perfect or legally perfect theory, or else it becomes extortion. First, I'm not convinced that ordinary settlement demands are even within the scope of the extortion statute to begin with. I suppose you could view them as falling under the alternative of threatening to cause a public official to take action. But the Donahue commentary describes that alternative as threatening to use one's influence with a public servant to cause taking or withholding of action to injure another. So that kind of has a different meaning than commencing a lawsuit and using process of law to recover on a claim. It's more about a improper pressure on a public official, some sort of a back channel. But even if a settlement demand could qualify as extortion, it would be covered by the defense under 711(4) sub 3, as long as the person reasonably believes they have a right to make it. And then common practice surrounding settlements and letters becomes relevant. The content of the letter articulating the basis for the demand becomes relevant to help establish that defense. And I understand the concern that there may be instances of an overzealous prosecutor bringing a charge when this, a reasonable fact finder should find that this defense is established after the evidence is presented. The jury is the check on that. Prosecutorial discretion is a check on that too, and but if that fails, the jury is the check. The jury applies the community's judgment, can hear all of the evidence that bears on the objective reasonableness and the truth of the assertion in the subjectively held belief.
Mr. Sloven, you do in your brief, you make a persuasive case for this sort of nexus test, and then you line up the cases and show that some jurisdictions either explicitly or implicitly have adopted it. The thing is, we don't really need to adopt that test to decide this present case, and I'm always worried about, I don't know all the ins and outs of extortion, and I'm just worried about the notion of adopting some broad definition of what is and isn't extortion on something that isn't spelled out in the statute, and then somehow, regretting what I wrote or what I signed up to on one of my colleagues wrote at some future date.
That, and Your Honor, you can alleviate some of that danger by couching this in factors that may be relevant in determining whether a belief is objectively reasonable. I would urge this court to look at this similar to when you're remanding for retrial and then addressing an issue of the admissibility of evidence that is likely to recur at the retrial, where this is the same thing, that at the close of the evidence, please.
Well, I'm thinking of this as a relatively short approach to you winning in this case, right? We show that the district court shouldn't have granted this motion, and then it just feels like that all these issues, and for our students, usually things get hashed out in the first instance at the district court, right? Theories of what the jury instructions ought to look like and how the evidence actually comes in and all this sort of thing. Then once we have all that done at the district court level, that's usually when we start doing the management of these particular legal issues. Do we have to reach all that, or can't we wait?
I would agree with you that I don't think you absolutely need to reach all of that. Now, the advantage here, first, this isn't a constitutional issue. There's no constitutional avoidance in play here. The other thing is that the district court already weighed in on this, it considered, it read the statute, it addressed arguments on statutory interpretation, and it said this is per se objectively reasonable. This is a per se reasonable belief, and here are the facts that establish that. And it mentioned some, and then it overlooked others. And I think this is ripe at this point to use this as instructive and say, when you're doing this kind of analysis, and later when you determine whether there's substantial evidence to support submission of an instruction, here are some things to consider. Not here's a result you must reach, but here are some guideposts to enable your analysis for you and for other district courts. I see my time's pretty much up. Thank you.
I went to Dowling Catholic High School here in Des Moines and graduated in 2005. And yes, I did know Mr. Sloven. We were both on the speech and debate teams together, so we've been arguing against each other for 20 years now. This is a case where prosecutorial discretion has fallen, and it is time for the Iowa Supreme Court to say, that's enough. You have twisted our extortion statute enough that you are encroaching upon reasonable settlement demands, which we want to encourage and we want to have, and turning them into prosecutions where people will have to undergo jury trials, which are stress-inducing procedures, costly procedures, where people are threatened with time in prison because they are while they're going through this. And it might be helpful for the court for people to hash those out, but people like Mr. Bailey, who is here, have to undergo all that stress and that pressure while they are going and being prosecuted. Now, typically, in motions to dismiss, what the court assumes is that everything is what they're saying in the minutes of testimony is true, and then sees if a crime has been committed. And that's all we're asking the court to do today. Go through the minutes of testimony, see all the things that make this a reasonable settlement offer by Mr. Bailey, and then affirm the district court judgment.
Is being settled. As I read that letter, I don't really see any tort claim that your client had that he was offering to settle.
Bailey refers to what is both a criminal and a civil complaint that he has and the email that he has, and then he goes into the facts of what the Coombs has done, which is go around.
The civil claim that's being settled.
Probably be an intentional tort based off of them being there. Mr. Bailey is not an attorney, and so he feels that he's been legally reasonably wronged as he is expressing this concern, but he doesn't have all of the aspects that you would expect if someone had an attorney and actually sent out a formal demand letter.
Between the lines, your client was upset because a sex offender was involved in service of documents. So apparently that is so offensive that he needs $10,000 or he's going to tell the employer and turn it into the cops and civil rights or something like that. So doesn't that kind of fly in the face of his, if he takes such umbrage to somebody who's on the sex offender registry, that if you pay him, he won't tell the people who could actually fix such a horrible thing? Doesn't that fly in the face of having an offense or something compensable that he's talking about? Let's keep it a secret. I promise I'll keep it a secret so other people can be damaged. Just pay me.
Question Mr. Bailey's motives, but the statute says it is legal for him to threaten accuse someone of a public offense.
Chip, like that question I asked about earlier with the state's chip. I'm a former prosecutor. I wouldn't think that anybody in my community could, or in that county at the time, could start bargaining or leveraging criminal charges, and that I would be bound to that.
I don't think that it's saying that he can settle them, but the statute does say that this is that these are the instances in which you can leverage accusing someone of a public offense. And there's only one exception to it. You can't say you're going to commit a public offense in order to get a settlement. It does say that you can accuse someone of committing a public offense or advance that cause. I'm sorry?
Reasonable.
The reasonable has to do with the objective nexus requirement that Mr. Sloven has talked about. I think that there does have to be some connection between the perceived wrong and what they're trying to settle, right? It wouldn't be okay for him to say that he was going to expose nude photographs or something, and which is what all the cases are about. But this arguing with the state's chit, that comes from law review language. It's not from our statute, which clearly says.
Point is, the law enforcement, or the prosecutor is the one who possesses the authority. If you want to call it a chit or authority, I don't care what you call it. But the point is, it sounds to me like he's trying to negotiate with something that doesn't belong to him.
And I don't think that that's against the law in the state of Iowa. I don't think that he's saying that I can settle this criminal case, but I think that you can accuse someone of doing a criminal offense as part of settlement negotiations.
And this gets back, I think, to Justice McDermott's question, and maybe the Chief's as well, that he has to be trying to recover a debt to which the person has a good faith claim. And can we really say that that standard's been met just from the minutes, that there's a good faith basis that he was owed $10,000 because of this incident?
You can look throughout the facts of the case. I would love to talk about the facts of the case. I mean, he's saying specifically in there, I have a civil complaint against you, and I would like this amount of money in order to settle it. We've had a continuing dispute. I had another claim of racial harassment against you.
I mean, why not let the case go forward and let a jury resolve it? It does seem, and the jury can decide if there really was a good faith claim or a shakedown. What's wrong with that?
What happens with that is that, well, it doesn't meet the standards of the motion to dismiss, which is we can assume these things are true, and we can see that it's a good faith claim just from the facts. And then if we let the jury resolve all of these questions, it puts our entire system of settlements and talking the cases out at jeopardy.
Standard on motion to dismiss. You keep saying we can look at all the evidence and, I guess, determine the factual issues. I thought the standard here was whether or not the trial information and the minutes actually stated the elements of the crime.
That is the standard, Your Honor. But I think
It does. We're here debating an affirmative defense, which has nothing to do with the motion to dismiss.
fit the affirmative defense, then it doesn't state all the elements of the crime. That's something that if we get the affirmative defense, then the state has to disprove the affirmative defense, so it is an element of the crime.
What is your best case on that?
The best case on that is probably when the court took a look at asked for a motion for a bill of particulars. I'm sorry, the exact case is not coming to mind right now. But they asked for a bill of particulars, saw that a defense applied, and then motioned to dismiss off of that.
Two separate things, though. It's not whether or not the state could prove each of the elements of the offense. It's just whether the minutes state the elements of the offense, right? We're not judging the sufficiency of the evidence at this point. And that's particularly true when you're asserting an affirmative defense.
I think that you have to look at the facts, not just whether it states the elements. And so it has to, those facts that are within the minutes of testimony need to meet all that elements of the defense. And if they don't, because a defense applies.
I could see a situation, I mean, where, you read the minutes of testimony and the information is clearly barred by the statute of limitations, so you move to dismiss. But in any situation where you're going to have to weigh the evidence to decide whether the defense applies, how do you do that on a motion to dismiss?
Way to the evidence, as Mr. Sloven on the state argues, this is an objective standard, like reasonable standard. So you can look at the facts and legally decide, okay, yes, that is reasonable.
See if I understand it. Isn't it reasonably believed? Is that part of the defense? Yes. So isn't that an issue of fact at the end of the day?
It's an objective standard, so it's a legal issue that can be decided by the court.
About whether or not he believed that whether or not the defendant had reasonable belief that he had a right to make such threats, that necessarily requires a finding that you believed it, right?
Reasonably believed means that it has to be an objective standard, right? But even then, the court
Aspect of that.
probably a subjective aspect on the good faith claim, but the court decides issues about beliefs and what people think based upon circumstances all the time.
Well, for example, a justification defense, you could have the whole incident occurring on video, and so it's all there, but it still would be up to the jury, not the judge, to say whether the defendant's belief that she was acting in self-defense was objectively reasonable or not, right? It's still the jury's call, right? Not the judge's call.
point, we're talking about like a reasonable beliefs and objective beliefs about litigation that is within litigation, right? Because we're seeing that he has a reasonable belief to recover debt. So I think that's uniquely within the judge's purview to say, yeah, I believe that is a reasonable belief based upon how I view the law. Sorry, a moment. Anyway, I do want to come back to this point. You can couple a threat of criminal prosecution or to accuse someone of criminal prosecution as a way to try and settle a civil claim. That is allowed by the statute. Reading the statute, the only thing you can't do is accuse someone of committing a public offense. And when we're looking at that reasonable nexus, the court should construct the statute to fit with public policy, which favors settlement, which means that the court should encourage settlement demands, be happy that people are trying to settle things outside of court and without using judicial resources. We, of course, use the legal system in order to resolve disputes nonviolently, but if people can talk through these, make settlement demands, and then...
What was the civil tort that was being settled here?
I believe it was an intentional tort of having this sex offender come to the home. I'm not saying...
What's that petition look like?
The petition will probably looks like you violated the statute in this way, in reference to the child care facilities, right? Would probably be dismissed on a motion to dismiss civilly. But it would just be like, you committed this crime against me, and I'm demanding recompense. It doesn't have an exact specific name, but it would look like any other lawsuit for an intentional tort like assault.
You're correctly, you're conceding that this civil claim, whatever label we put on it, would probably not survive a motion to dismiss. It would get tossed out, right?
Probably, yeah. Mr. Bailey is not an attorney. He was acting pro se. He felt like he was legally wronged and was trying to resolve this as a reasonable person would through talking it out.
Asking us to find that the court could rule as a matter of law he had a good faith, objectively reasonable claim to make?
The reasonableness requirement requires Mr. Bailey to act with perfect knowledge of the facts or of the law. In fact, I think he's allowed to make mistakes about it. That sort of encourages people to resolve their disputes outside without even using lawyers, right? They can talk about them, like, you hit my car, can you give me the money, etc. Yeah.
State's argument that with this kind of demand that your client made, when the demand is pay me money and I won't turn you into the cops, and then tomorrow he makes the same demand.
If you settle a case like that, right? If he says pay me money, I won't go to the cops, will resolve the civil claim. You sign a settlement agreement, and then you don't do that. Then I don't think it continues onward and onward.
From doing that.
What would prevent him from doing it would be contract law. I mean, it's the same.
Negotiable. Your guy's email says non-negotiable. Sounds to me like no more terms are going to be involved. Pay me, and we're done. I didn't see anything in there where we will tie it up with a bow, and I'll promise that I don't turn you in again. So I'm just using your client's words, non-negotiable.
To say that he was making a final offer, he wasn't going to entertain any other new terms, but I did think that he was going to say, I'm not going to do this. Which again, you can couple a civil claim with a threat to accuse someone of a crime. That's in the statute.
The heck did that come from?
Damages for pain and suffering, for medical expenses, for any sort of expenses are discretionary. So arbitrary is...
Say any damages are discretionary. I mean, doesn't it weaken your client's case to just have what appears at first blush to be a number pulled out of the air?
I think that how we get all numbers for any settlement demands from any law firm in the state is primarily discretionary, and
Probably doesn't have any legs.
he doesn't know that it has any legs. It still has a reasonable nexus to how he feels it would have been wronged.
Client got in a car accident, just a fender bender, and he said, I won't turn you in when you ran that red light if you pay me $1 million. Is that okay?
You know, the statute doesn't No, I don't think the statute envisions that the court is going to get involved into what settlement demands are about what sort of damages and whatnot, and whether that we're doing, again, litigation about litigation in these sorts of cases. I see that my time is almost up, unless there are any further questions.
Thank you, Your Honor. May it please the court. I wanted to comment on this idea that the statute should be construed to favor settlement and to somehow exempt settlement demands from its scope. There is already a carve-out for when you reasonably believe that you have a right to make a settlement, to make the specific threats and demands. But I also want to point out that Donahue's commentary on the new criminal code at footnote 1343 cites a Vermont case called Harrington, and the way it summarizes it is a lawyer's demand for a settlement of a civil action accompanied by a malicious threat to expose the other party's criminal conduct, if made with the extent to extort payment, constitutes extortion. So I think this kind of, a settlement demand that would be non-criminal, but with an additional unrelated threat made maliciously in order to extort the payment qualifies as extortion, and captioning it as a settlement demand letter doesn't save it. I also want to mention, if you look at the actual emails, now I think that the court is asking the right questions about, is it really, at a motion to dismiss, we've got the factual issues of both subjectively believed, did he really believe it, and objectively reasonable, same way we do it in a justification case, that this is for the jury to decide. But I want to point out, as long as we're talking about the importance of facts that we have and the weight that could be given to them, in the emails that Mr. Bailey has sent, his first email does not talk about civil or tort liability or any amount of damages at all, or any injury. It talks about, I have discovered that you committed a crime and you can be charged. And that's the basis for the claim. And then in the second follow-up email, he says, I just found out that Mr. Vulich was a sex offender 2 days ago. That's the reason for sending this new evidence for charges and arrest. So it's clearly threatening the criminal prosecution unconnected to any, the post hoc justification. And that's, the validity of a legal theory concocted after the fact really doesn't have much to do with the state of mind at the time. And the state of mind at the time, very clearly shown by the emails, is now I can put the squeeze on, I have leverage, pay me the money or I will turn you in for a crime. And anyway, but I agree with you that at this stage, right, it's essentially moot, because when we go to trial, there's going to be a trial record on which the court will determine whether there's substantial evidence to support submission of a jury instruction on this defense. But it would be useful, the same way that a court would love to have in hand guideposts for assessing the admissibility of evidence that we know will be admitted on retrial. It would be useful to have some guiding principles on what facts or factors are like or will help demonstrate the objective reasonableness of a belief in a right to make such threats, and what kind of facts or factors may foreclose objective reasonableness or make it less likely. Things to weigh and consider, and authorities, specifically to have this court direct district courts to authorities that they can rely on in analyzing this issue. So, unless there are any further questions, thank you.
State versus Bailey is hereby submitted, and court is adjourned for the afternoon. And just to let the students know, as a full court, we will conference our cases and our opinions come out later at another time, sometime this term, which is the end of June. So just to let you know, since you sat here for the hearings, you might be interested in watching when they're published. Thank you. Court is adjourned.